Um, welcome. So, let's get started. I'm actually going to stay off camera. Just so you all know, I'm in the middle of a move, so my apartment is disheveled. I am disheveled, so I'm going to stay off camera this time. I think we have most of the same group of people that have been attending our office hours. So maybe we don't need to do full introductions, although I think maybe I'm not familiar with Chase, and I've met you before, Armin, but maybe you have a new role now. Do you want to? Should we do quick intros? I'll maybe just the people who haven't joined before. My name is Edwin Sun. I'm a housing planning and economic analyst at LHD. I worked on developing the pro forma, the pro forma, but also the NOFA regs. And these are our twice a week office hours. I'm going to let Chase and Armin introduce yourselves.
Hi, my name is Chase Wilson, and I am an asset manager with ACOF, with a community of friends.
Yep, great. Good to meet
Yeah.
you.
Hi.
Armin, do you want to say a few words?
Sure. Hey, Edwin. Hey, folks. I'm Armin Nashad. I'm here from Decro Corporation. I'm our real estate development director.
Awesome. I should note that our set 5 of the Q&A was published earlier this week. I can't remember if it was Monday or Tuesday, but we answered about 120 questions in that one. So I do want to make sure that you all take a look at that latest set, in which we have also made some refinements and revisions of answers that we've given in the earlier sets. If anyone has new questions, I don't know if you want to raise your hand or just go off mute and we can just we have an hour. I think we can answer everybody's questions. Emma.
Hi, Edwin. Sorry, I'm just unmuting myself. So I'm Emma with Wakeland, project manager there. And my first question was actually a scoring clarifying question regarding section 7.7 priority population served in a NOFA. So I wanted to get confirmation that projects which set aside 10% of their units for 3-bedroom units will receive maximum points because the NOFA states that max points will be awarded to projects that set aside an additional 10% of homes for LA NOFA. But by some, I noticed that the homes for LA NOFA doesn't state like this requirement for the number of 3-bedroom units. So we just want to make sure that if we set aside 10% of our total units for 3 bedrooms, that will receive the max points for that criteria.
Yes. So and I've answered this before, and it's also in the Q&A sets. So look for it there, but I'm going to answer it here. So you are correct. In none of the 7 NOFA programs is there a requirement for any 3-bedroom units. So by providing 10% or more of your project's units as 3-bedroom units, you would in fact meet that scoring priority and get max points. You would have 10% more than the minimum. Of course, we have other priorities in there. We have the ALI, ELI. We have we have seniors. So there is one program where there is an ALI. There are 2 programs where there are ALI, ELI requirements. Those are the 2 alternative models, the preservation and then the alternative models new construction program. Those both have a 20% floor for ALI, ELI. So if you were trying to get these additional priority population points by getting additional ALI, ELI, you would have to be 30% of your units at ALI, ELI. I hope that makes sense. And again, it's answered in the question sets.
Thank you so much. Thanks.
Okay. Anyone else? I think maybe you can just come off mute.
Hi, Edwin. I had a question regarding the memo that was just recently released, giving more guidance on the entitlements points breakdown. I have a project that has a PZA, but it doesn't require planning review because it's an AHIP ministerial project. So we're not technically required to obtain a letter of compliance or a letter of determination from planning. We saw the PZA only scores 8 out of 15 with the new scoring criteria. So is there anything else we could provide to get the full points, or any further clarification would be helpful?
We lay out in the technical addendum memo that the only documents that we will accept for the full points would be the letter of determination from planning where the appeal has expired, the letter of compliance from planning, or the ready to issue letter from Department of Building and Safety. And part of our department's reasoning for not accepting the preliminary zoning assessment form, which is what you have, is because the AHIP process is very new, and we do not have full confidence that the amount of information that is present on that PZA form is sufficient to demonstrate that you are fully entitled or fully approved to go ahead through a ministerial process. I believe we also elaborate on this a little bit more in the um, in the technical memo, but that's our reasoning. It is that we are aware that many applicants will regard that as that PZA form, that preliminary zoning assessment form, as your full approval, but we do not regard it as such after speaking with our counterparts in planning and in DBS. So at the same time, I encourage all applicants to not think of not getting max points as as a death knell for your project. Many applicants will only be able to demonstrate up to what is 8 points with the PZA form.
And Edwin, I was looking at that section too, but we have a preservation project, and it looked like that memorandum includes preservation in that, but I guess, yeah, I was wondering if there could be some type of differentiation on the preservation, right? Because we're not, like, the scope is just rehab of an existing building, not adding units, not increasing density, nothing like that, right? So are those going to be looked at any differently, or are we also going to be required to get these other things that really shouldn't be necessary for a rehab?
Do you think that your rehab project will require you to pull permits?
Yeah, it'll require permits, but I mean, the pulling of permits doesn't trigger like doesn't necessarily trigger a need for a planning action.
Right. Um, I think you bring up a good point, and I think we need to maybe refine a little bit more on this one, for specifically for preservation projects. And this question has been asked in the past. So we'll answer this one in the next set.
Okay, thank you.
Hey, Edwin, with respect to the regs stating the pro forma must show positive cash flow and DSCR of 1.15 or more, are there any thresholds to the cash flow? Because I'm pretty sure anytime you hit a DSCR of over 1.15, you are going to have automatically positive cash flow. So is there any kind of benchmarks for the positive cash flow? I know it just says positive, but I think you're always going to have that if you hit the 1.15, unless I'm
Yes,
looking
it
about
is.
it correctly.
It is essentially, so our underwriting standard for what will be, there are underwriting standards for what we would ideally have, and I think that's been a source of continuing confusion, and I think we need to do a better job at being clear about what knocks you in and out and what gets you docked a little bit. So
Right.
to be considered to move out of our threshold review for all 7 programs, you need to demonstrate 1.15 DSCR for 15 years of your cash flow. I'm going to address, so there's that one point of confusion about whether there is any additional thresholds for your for your cash flow, no. There is also guidance that I think has been confusing, that in our project underwriting, we asked to see 55 years of positive cash flow, and that is a goal, not a requirement. So the requirement is 15 years at DSCR at or above 1.15. And then there are lots of other things in there that are nice to have.
Right, but it says positive cash flow and that, so you're always
It
gonna
is
have
part of
positive.
it. Yeah. The positive cash flow is part of the DSCR being a 15%
Right.
margin over your debt service.
Okay. And not really a second question, but is this the last office hours or is there another one?
We will hold one more next Tuesday.
Okay.
And thank you for that. I meant to address this at the top. I just want to remind this group that LHG has committed to answering all questions received before October 14th. And we will try to answer questions received after that date. But as you all know, it takes us time to get to certain answers and policy discussions and negotiations. So we are not able to commit to answering all questions submitted after the 14th. And so I believe we will probably cut off the office hours after next Tuesday as well.
Thank you.
Hi, Edwin. I spoke with you last time also about this issue. We are in the pool project and new construction, and the question is about appraisal. What type of appraisal? We have prepared an as-is appraisal, but I'm kind of confused. It looks like now for capital projects, which probably our project also falls under, there is a requirement for as-built appraisal as well. And the question I have is, if that's the case, we don't have very much time to meet the deadline with the as-built appraisal. Is there any other way to handle this?
So some of our staff have been confused about the as-built versus as-is appraisals, and I'm sorry that some of the communications have not been clear. I'm telling you what our policy is. Even though the regs talk about both the as-built and the as-is, we since published underwriting guidelines that state very clearly there that we would prefer the as-is appraisal, and we do not want to see the as-built appraisal unless you have extremely extenuating circumstances, such as a seller that is absolutely unwilling to sell at the as-is appraised price and is demanding a higher purchase price, and that would need to be supported by an as-built appraisal. But we do not want that price. We do not want to pay that acquisition price. And in fact, we will dock your application if you use an as-built appraisal. We will dock your application via the cost effectiveness scoring criterion if you use an as-built appraisal to support a higher purchase price.
Thank
So
you very
please disregard what you heard from the others.
Okay,
That is not
thank
correct.
you so much for clarifying that. Just the follow-up question regarding the same issue. In our case, the property has already been owned for a few years, so we just do it as is to just show the current market value, correct?
We still, yes. So that is another group of questions that we encounter frequently, and it is about why do we need an appraisal if we don't obviously need an appraisal for this transaction? And it is because on our end, in order to secure the LHD loan with collateral, we need the appraised value. So yes, we still need the appraisal, but the guidance is that we want to see the as is, and we do not want to see the as built, and we will dock you for tying your purchase price to the as built appraisal.
Thank you so much.
Oh, thanks for clarifying that, because I think one of the Q&As actually says that the as-built is also required. So
Yeah. I think this has been a point of confusion for many of the staff, but I keep reminding people, and this is what I'm telling you actually is the guidance.
Okay, so we don't need both. If we have it as is, that's actually better and preferable anyways.
Yes.
Okay, thank you.
So the as is fine for new construction.
We want as is for all of the programs, and we will not even consider the as built unless you provide a very strong reason. And we see your project as so amazing that we would want to fund it, even though you are paying an exorbitant acquisition cost.
Got it.
Sorry about that. I hope I'm being extremely clear now. We do not want to see the as-builts.
Okay.
Thank you, Edwin. This is really helpful. This is Emma again. I just had another quick question regarding the preliminary zoning assessment. So our entitlements consultant said that usually it takes about 4 to 6 weeks to get that from the building and safety department. And we wanted to know if LEHD has touched base with the building and safety department to maybe expedite the delivery of the PCA forms. I saw in the technical guidance addendum, it said something about like a temporary kind of PCA, or that they understand a PCA will be used for this application. We're a by right project, so we just want to make sure for reaching out to building and safety that we could get that document in time. So do you know if there's been any discussions between LEHD and the building department regarding PCAs for these applications?
Yes, so the entitlement scoring methodology that you see in the technical addendum memo was produced in collaboration with both Department of Building and Safety, DBS, and Department of City Planning, DCP. So DCP and DBS, we worked with them to understand what exactly one department understood the other department's document to mean. That's part of why. So back to your point earlier about the PZA being insufficient is because we did not ascertain for certain that DBS would accept the PZA as ministerial approval and all green lights ahead for them to do their ready to issue letter. And so that is why we moved that one down into the 8-point category. And then regarding your new question about timelines, we worked with them to understand whether they felt that these documents could feasibly be delivered in the narrow timeframe that we still have left. I don't know that they committed to being able to do the PZA completion or deem completion in the time that we have left, but that was a very important topic that there is time pressure, and this is the process that we worked out with them, and we are fully aware that many of you will be unhappy with this, that not all of you will be able to get full points, but we have laid out a very clear standard for who will and will not get full points, and the full points are supposed to be very hard to get, and we expect many of your peers will also not get full points, and you will end up largely in the same boat.
That makes sense. And then for the PZA, it sounds like we've already kind of reached out to request that, or we'll be doing so today. But if for any reason that's still pending LADBS, but it's on the way with like email backup, maybe support if we don't have it in time for the application. I just don't know if that's something that can come later or would be extended to submit, just since it typically takes longer to get PZAs apparently from LADBS.
Yeah, I mean, I know that we provide some partial points for applications for some of these forms that are deemed partly complete. I don't think on that particular one. Yeah, I'm looking at it, and I don't think on this particular one that there will be partial points for having
yeah, if we don't have the PZA, like an email or something. Okay, we'll work.
Yeah, this is fundamentally something
I'm
that is
sorry. I just had another question about the technical addendum. We were talking about scoring just a moment ago. So we noticed that for the health of existing be ranked relative to all other sponsors submitted, but the document for the REO schedule asks us to report all LA County real estate owned. So we wanted to know, will LH be curving or ranking the sponsors based on their LA County real estate owned, like relative to each other?
I didn't hear, I think you broke up a little bit, so I didn't hear all of your question. I heard the last part about
Oh, I'm sorry.
the REO. I
Mhm.
heard the last part about the REO schedule and whether or not we will be grading on a curve specific to LA County projects. Did you have another
Yes.
part of that?
Yeah, that was the question. Sorry, I'm on a train. that was the
No.
question. Yeah, that one.
Yeah, no worries. We would like to look at the broad portfolio, and if you're thinking about it from our perspective, we are simply trying to assess the risk of the project and the ability of the project sponsor to assist and navigate complex financial, legal, economic challenges. So we would like to take a broader view of the portfolio. I think there's some reconciliation to do about the guidance we've given regarding how restrictive of a portfolio you can report to us. So in the past, I think in some of the earliest office hours and some of the earliest questions that we've gotten, we got pushback from several applicants who said you have gigantic portfolios outside of LA County and don't necessarily feel that those are relevant and don't want to report all of those things. We did not have an opportunity to get a lot more additional feedback about how we should restrict that. So right now, the guidance is just to report everything that you have, and we do want to see the health of your entire portfolio.
Okay, that makes sense. So not just restricting ourselves to our LA County projects, because we're based in San Diego, so we have a lot in San Diego area.
We definitely want to see your San Diego projects.
Okay, perfect. Yeah, we'll include everything then. Thank you.
Okay. Anyone else?
Hi,
Edwin,
yes. Hello. This is Corey Felposh. Sorry if I interrupted. Just a couple of quick questions on the specifically the ULA alt mods preservation. One is threshold item number 8, projects involving demolition must identify lead and asbestos hazards. So I do have a project. There's a little bit of demo, but it's only demo to some of the concrete stairs and existing handrails to uh, so that they can be more ADA and accessibility compliant. So even something small like that, is that considered demo, or are you just, when you say demo, are you referring to like significant, like knocking down walls?
Usually walls.
Okay.
I mean,
Good to know.
the asbestos would be used as old insulation within the walls. I think it would be best if you sent us an email about this specifically, although we will notate this from this conversation. If you are recommending that the definition of demolition be more specifically aligned with demolition of walls where the asbestos is likely to be located. I think you might have some policy recommendations about how exactly that should be handled. We're happy to still take that feedback, but yeah, from my perspective, I had always assumed walls because of the insulation use.
Okay. And then where would you recommend I email? Is it just the
The-
address you have on your website?
Yes, I'll
Okay.
I'll drop it in the chat right now for good measure.
Okay. If it's the one on the website, I
Yeah.
could do that. I just want to make sure it wasn't anything different. But that is helpful. And then another question. So we have to provide a relocation project summary assessment. So if so our plan is to have hotel units within the building. So if we have someone that's like in unit 102, for example, and then unit 101 is vacant, they would just move all their stuff from 102 into 101, and then the contractor would come in, update unit 102 with, new flooring, new appliances, etc., and they would move back in. So relocation project summary assessment is just something like that in narrative form, good enough, because like we're not going to be relocating anyone into like hotels that are off site, so we wouldn't have to pay for like hotel costs, U-Haul costs, storage costs, things like that.
Do any of those residents have established tenancy and a lease with that hotel unit that they are being
No, so it
evicted
would
out
be
of?
like it yeah, so it would be like so it would be John and Jane Doe has a lease with unit 102. And so what would happen is um as the contractor's coming in and they're going into each unit and just doing, all just the, updating, that's part of the rehab. John and Jane Doe with the lease in unit 102 would temporarily move to unit 101, let's say for like a week while that unit um, is undergoing its rehab. And then once unit 102 is complete with like, new flooring, new appliances, etc., they would move back in to 102 where they have their lease. So they would still they would be in unit 102 before and after. It's just within that, week or so where the rehab's going on in that unit, they would just be temporarily relocated into a different vacant unit within our building. Is that making sense?
I understand the situation, but the
Mhm.
fact that they have a lease and
Mhm.
are established tenants in that units makes me suspect that the relocation plan, even a very abbreviated relocation plan, is still that requirement is still triggered, and it is normal for a relocation plan to address some of these simpler short relocation issues. But
Mhm.
it is my understanding that if they have a lease, then even temporary relocation requires that you provide us a plan. I can double check with the
Okay.
relocation staff, but uh,
Okay.
maybe there's an exception for something of that time period of less than a week or so. Okay, we will check on this one.
And the very last thing, kind of on that same topic. So, um, the replacement unit determination, a scenario like that, we would or would not need to provide an RUD.
Are you proposing, would there be any net loss of units, or are you replacing every unit that is being rehabbed?
No net loss of units, no additional units. It would be just a substantial rehab to each existing unit. So if a project, for example, is 76 units before, it'll still be 76 units after.
Okay, then you do not need to submit the RUD. If you look on one of the sets, I can't remember, there's a link to the no net loss form, and you can just fill that one out instead.
Oh, and no, fill out no net loss
Yeah,
form.
there's a no net loss certification. There's a link to it.
Okay. Okay, and that's all I have right now. And apologies to Jessica for interrupting you.
No, that's all right. I had a similar question, Edwin. Is a GIN required outside of the pooled sources program? Or is that
It
all?
We will require the GIN is the general information notice, and we will require it outside of the two pooled sources programs, but we do not require it to be, we do not require the GIN, so those notifications, to have occurred by the time that you submit your application. The difference is that because there are home dollars, which are federal and HUD administered dollars, um, so those home funds in the two pooled sources programs trigger a GIN requirement that is more aggressive, and the home regulations specify that the GINs need to go out, meaning the residents need to be notified by the time that a developer or the owner of that building applies for an additional funding source to do something to that project that might displace those residents.
Got it. So you're only looking for like a template of the GIN for like ULA conventional, not necessarily proof that it's already been distributed.
Yeah, you can present a narrative certifying that you and promising that you will notify the residents. And we are planning to implement that requirement for all the ULA sources at the time that we make the award letters. So we are proposing that you notify the residents then, but for the pooled sources, because of those home funds, we have no flexibility, and you are required to notify them immediately.
Great, thank you.
Yep. Did you have any other? Oh, Vanessa.
Yeah, on the relocation topic, there was a mention, I think it was in the NOFA, I can't remember which document it was, of a relocation assessment. And one of our relocation consultants that we're using was not, and it's like an assessment form. And one of our consultants was not sure what that form was and didn't know what was being referred to. So I wanted to clarify if there is a specific form that LHD is looking for, or if it's more just like the plan and the relocation documents that be provided along with the plan.
I'm not sure what this answer was regarding a form. I can tell you that all of the relocation plans that I've seen look a little bit more like a report than a form that you fill out. So that's what I've been expecting. I think we should jot down this question and make sure to look for the other piece of guidance that we've provided and make sure that that's clear. But and maybe there's something to that. But I hesitate, but I have always seen them look a little bit more like a report.
Yeah, I mean, that's how I've seen them too. So we wanted to clarify. And then I just wanted to ask also, it looks like we've started in some of our applications on inputting the numbers in substantially into like the old pro forma that was provided by LHD. Would it be possible for us to send that to you to update the formulas, or do we have to fill the whole thing out again on the new ones?
I was dreading this question.
I could tell you knew it was coming.
I'm open to this. So let me just say that the pro forma modifications that we've made are really tweaks, and I don't think that they will wildly affect most people's projects. That being said, we do want to provide you with an equal playing field, and I'll just share that one of the refinements that we made was that we broke out the property tax operating expense as a separate item, and then broke out the property tax cost escalator in the cash flow tab as a separate item, and allowed applicants to escalate the property taxes at only 2% rather than the standard 3.5% that we apply to all other costs, because of Prop 13 protections allowing property taxes, not allowing property taxes to go up with inflation as much. So if you want to take advantage of that, the obvious way would be to download the new form and fill that out if you haven't. If you've already substantially filled it out, I think we can entertain the possibility of us going through and just manually making those changes for you. But I hesitate to commit to that because I don't know how many people will ask for that, and I don't think that we will have the capacity to do that for everyone. But can you send it to us and we will consider this?
Sure, thank you.
Okay.
Edwin, I have another question. For some of these strategic partners and consultants, as well as if we have some sort of a funding available from standard lenders, would just the letter LOI suffice for submission, or what kind of other documents is required?
Oh, sorry, I was on mute. Depending on it, it'll depend on the funding source. Most of your funding sources will be familiar to our underwriters, but we are looking for commitment for if you are, let's talk about this in terms of the pro forma workbook. So there's a tab for your sources, for all of your funding sources, and you need to make very clear on that funding sources tab what your capital stack looks like, what parts of it are not yet commitments, what parts of it are already committed, and then we need firm commitment letters or executed loan, an executed loan agreement would definitely be fine, but any legally enforceable document would be, of course, fine. And then if you do not have a legally enforceable document because it's quite early, you can send us some kind of commitment letter from that funder saying that they have set aside the funds for you.
So the LOI, would that be part of that? Would be something acceptable with some sort of a short deadline?
Which funding source is?
Let's say we have a bank that we haven't entered into any agreement yet, because this project is, by the way, shovel ready. But they have reviewed the application and they are ready to fund, but we haven't gone forward. And so we have received an LOI with the interest rate, the terms, all of that. It's just that we don't really have a contract with them.
Yeah,
Would that
it's
LOI
kind of like
work?
it's kind of like it's sort of like a pre-qualification letter.
Correct.
Let me check with our underwriting team and see if they accept that.
Okay, and then the same thing goes with partners. Let's say we do have consulting companies that they're helping us with the financial and reviewing of the and also the cost and scheduling. If we to just show that we are basically minimizing the risk, would also in those cases an LOI from those firms be sufficient?
We actually do not expect the various consultants to always be contractually engaged or contractually obligated at the time that you submit these applications. So we recognize that some of these projects are pretty early in the pre-development process. So we ask for that information because sometimes the applicants do have the information about the various consultants and contractors. So provide it if you have it. I don't think we are going to be docking people for not having some of these consultants.
Thank you.
Edwin, what about an AHP loan, which would be uncommitted since it's secured after the tax credit reservation, but TCAC usually accepts that as a source. Could we include that without negatively affecting the feasibility scoring?
The AHP loan?
Yeah.
Sorry, I guess I'm not understanding why that would negatively impact.
Because it wouldn't be committed. It's usually obtained after getting a tax credit reservation.
Right, but we're not room docking points from
For
no
not
no
having
one
a
will.
committed source?
Sorry.
For not having a committed source?
Well, your tax credits aren't committed yet either. So, right, like we're not saying so in our project underwriting methodology that we laid out in the technical memo, we say that we will be looking at the dependability and the probability of you securing your full capital stack based on your capital stack and financial strategy. So like let's just do a little bit of live interpretation of that together. Your AHP funds being awarded as part of your tax credit strategy does not I mean, it depends on how someone interprets it, but we don't expect very many projects applying for this NOFA to have secured your tax credits already. And so I'm not seeing why you would be unusually punished for not having tax credits nor having secured the funding commitment on AHP, given that you don't have tax credits yet. What we're trying to do is just implement a level playing field as much as possible, right? Like we know that you're not going to have the tax credit equity in committed yet, but you're in the same boat as nearly everybody else in this application.
Got it. Okay.
I-
Is the loan, the LAHD loan, is that if we use it for construction, is it a drawdown loan or is it funded up front?
I was also dreading this question. So I will tell you, I'm going to repeat the department line, and I'm sorry, but LHD is exploring all possible streamlining options to provide the funding in the form of a construction draw, which is what we can do now, but we have received a lot of pushback saying that our prevailing wage compliance monitoring um, is slow and delays those construction draws, but we have been and will continue to be able to provide the funds in the form of a construction draw and are leaving no stone unturned in our quest to move those reimbursements more quickly. But please know that we operate under strict legal constraints about how far we can go in providing or advancing funds that have not been fully vetted for prevailing wage compliance.
Got
And
it.
that's really all I can say about that right now.
Okay.
Hi,
Steve.
Edwin.
Hi.
Yeah. Hey, sorry to sneak in at the last minute here. Two questions relating to alternative models for new construction. So the first one is, for purposes of meeting the threshold experience requirement around tenant governance, is it sufficient to express a willingness to participate in ULA's future technical assistance and capacity building around that? Or does that experience need to already have occurred?
That experience, so the threshold for meeting the tenant governance experience requirement is multifold,
Right.
and is you are able to meet that by providing, I believe, 3 out of 7 conditions, only one of which is going through LHD's contractor for capacity building and going through their trainings. All the other requirements come from demonstrating that either you or a partner in your development team, including a contractor, have had experience doing tenant governance, and those other elements are all about, have you convened a resident council before that is elected to represent the tenants? Have you produced community agreements with them? Have they looked at budgets together? So most of those things are, again, actually demonstrating experience doing the tenant governance. And then one thing is you can satisfy one of those three. You have to check off 3 of the 7, and then one of those 7 things is participating in the trainings. But you cannot commit to doing the trainings. You actually need to have done the trainings. And at this time, our contractor was not able to launch their trainings in time to overlap with this NOFA, unfortunately. So I would say your option is to go look for someone to be contracted to your development team who is able to provide that background and experience by the time you submit your application.
Got it. Okay. I mean, I guess that was the question behind my question. That given that the ULA program hadn't launched yet, were you effectively pivoting that prong to be forward-looking? But it sounds like the answer is no. That one's off, and you've got to look to then the remaining 6 or whatever it is to satisfy.
That's right.
Okay.
That's right.
That makes sense. Second question. So we are in conversations with a group like that, and they've expressed it's a community land trust, and they've expressed interest in coming in to the ownership structure as well. It's my understanding that we can just have a proposed ownership structure at the time of application. We can put term sheets to support that the actual special purpose entity doesn't need to be formed yet. So I guess that's question part 1, just confirming that point. 2 is it sufficient that we just have a signed MOU with that community land trust, or do they also need to complete all of the other documents as if they were a full applicant, the various certifications, REO, all that type of stuff as well?
I hesitate to answer that. I believe we do name the MOU, but I think we need to get back to. We'll try to get back to you on that quickly.
Okay, thank you. And sorry, just to clarify, that's not only to meet the threshold, but if we actually intend to bring them into the ownership structure, we would hope to be in the priority CLT round for the alt models as well.
That's right. So the other parts of your question about them being in the ownership structure, that is what activates the priority, your priority in the priority pool for the alt models, for both of the 2 alt models programs. I will say that we have tried to be as flexible with as flexible as possible with the organizational structure of the sponsor, knowing that there is sort of a new sort of partnership that is being envisioned between the experienced developers and the CLTs. And throughout our sponsor underwriting, both for the sponsor underwriting guidelines and in this new technical memo, we emphasize that you can structure your partnership in different ways and draw on different parts of your development team to meet the experience and threshold requirements. So it's really not that we expect, like, for example, we know that the CLT would not pass our sponsor underwriting or do very well in our sponsor underwriting, which is going to be looking at their real estate owned schedule and their existing portfolio. It's going to be looking at the experience of their principals in developing and managing affordable housing. We don't expect them to do well in those things. So now that I'm talking out loud, our approach in the sponsor underwriting is to let you tell us which members of your development team satisfy that experience. And so if you have a sponsor that is a more experienced developer, and you have a sponsor that is less experienced but is bringing in the tenant governance experience, I would just recommend that you point to who on the development team should be rated for the experience and the financial capacity, and point to which members of your development team should be rated for their tenant governance experience.
That makes a lot of sense. And yeah, I appreciate the flexibility, because yeah, we're living that newness, as you called it, in kind of real time here. So okay, yeah, understand that don't each partner doesn't individually need to satisfy all of the requirements. My question was even just around like the logistics of the paperwork being 11 days out from application submission, but I can
Right.
look at that on a kind of a item by item basis and follow up with any questions there. Yeah. Thank you.
Okay.
Yeah.
Thanks, Steve. We have 8 minutes left. Any other questions?
Edwin, this is Emma Mizan. I just have two more questions. I know we were just talking about contractors a moment ago, but I noticed the the Homes for LA NOFA portal asked for information on our contractors' last projects. We wanted to know whether applicants need to name the actual general contractor on the application, or can we note to be determined?
Yeah, you do not need to have identified your GC at the time of the application, although if you do have that information, we wanted to be able to collect it. And in particular, some of those fields um, ex about some of your contractors' past experience, they're in there, for example, because we feel that an architect that has lived through our accessibility requirements and can name some projects that are LHD, ACHP compliant projects should be that experience is valuable and should be communicated. But again, we do recognize that many parts that there is a very complex sequencing to the development process, and you're very early in pre-development.
That makes sense. Yeah. And I saw like CAS, I don't know if we need to have that CAS consultant identified yet or just list who we typically work with, but is that kind of the same guidance there where we can say to be determined?
Sorry, I'm not very useful for answering the
Oh yeah, no
accessibility
worries.
questions.
Yeah, no,
So
that's
I'm going
fine.
to have to kick that one to our next set of Q&A.
That sounds good. And then the last question was just regarding the technical addendum. So the liquidity point section, it sounds like there was language that stated that, right? There's 5 points for that section in total for new construction sponsor underwriting scoring for the liquidity. But out of those 5 points, it said the remaining 4 liquidity points, LAHD will rank each sponsor relative to other sponsors submitting applications. So my question was, can multiple sponsors receive those 4 remaining full points, which would be the maximum there? Or will it be curved with most sponsors receiving less than 4 points? I think one point maybe went to like a sponsor's REO schedule, and then maybe the remaining 4 was based on this curve. We just wanted to know if most sponsors will be receiving 4, or is it limited or based on a curve?
Yeah, so I feel like I'm defending something that that a lot of applicants don't like, which is that we have set up a system where we don't want a lot of people to get full points. We genuinely want there to be bigger differences between scoring on all of our criteria when our underwriters are actually looking at something. And our intention is for a sponsor who has plentiful cash flow, who has plentiful access to, for example, a line of credit or the ability to quickly take on debt and pay that debt. Genuinely, our goal is to give that sponsor a 4, and then a sponsor who has very little cash, who has very marginal cash flow, who isn't able to take on debt and doesn't have a lot of available cash. Our intention is to give that sponsor a 1.
Okay, that makes sense. Yeah. Okay. So we'll provide as much information as we can then. And then I think someone asked few minutes ago, but I think it was just clarifying, for nonprofit entities that are applying, right, as the applicant, as the sponsor, do we need to have our limited partnership documents formed, like the LP1 certificate of limited partnership at the time of application? Or could we just say to be formed like LP or to be formed LLC?
To be, it'll be to be formed, and you know, we have forms for you to fill out and describe to us in detail what that entity is planned to look like, and we will have questions for you if you end up forming something that looks materially different from the ownership structure that you represented to us. You know, we're going to ask you who the managing partner is. We're going to ask you who the investor slash limited partner is. We're going to ask what the breakdown of the ownership shares are going to be. But again, this is early in the pre-development process. If you're a tax credit, if you're a tax credit deal, you could not possibly have your equity partner in there yet. So all of those forms are for you to tell us your plans for how that will shape up, and we're going to try to hold you to it.
Right, that makes sense. Yeah, I think it was I don't know if it was 4E or 4D, but I did see that. Yeah, I think maybe it was 4E, one of those forms where it had a section for like LP or LLC tax credit ID. So it seems like we might be able to, if we don't have that set up yet, at least for like the LLC and the managing general partner, maybe we could just say this is to be formed and then
Yes.
provide that information later. Great.
Yes.
Thank you so much.
Okay. I think we can try to answer one more question if anyone has any remaining. Okay. Silence is golden. This has been fun. Good luck on your applications. We'll let you know about any other. We'll let you know about whether or not we will hold one more office hours next Thursday. I think we are still definitely a yes for next Tuesday, but please submit your questions to us ASAP. We are 5 days from October 14th. And again, as I said, we may not be able to commit to answering any questions, all questions received after that date. So get them to us, and we will commit to answering all of those, hopefully with a few days to spare before you have to hit send on your application. Thank you all very much.
Sorry, Edmund. I got one more. I'll be quick.
Oh.
So back to ULA alt models. Threshold item number 7 says new construction projects must undergo evaluation of geotechnical engineering of subsurface soils. But this is alt mods preservation. So it's still in the alt mods preservation NOFA, but given that this would just be preservation, we don't need to provide a soils report to have that correctly. Well, I know we have to provide an ESA, we could do that, but the soils is just for new construction. Do I understand that correctly?
The geotechnical subsurface soil evaluation is for new construction projects. So
Okay.
I was a little confused if you were talking about a preservation project or a new construction project, but the requirement is for new construction projects.
I just want to make sure, because the reason why the term sheet for alt models preservation does say it does have threshold item 7, new construction projects must undergo evaluation geotechnical. So I guess I was a little confused, but you answered it. So
I think
appreciate.
I think it's in there because we are allowing, we do allow, so there are lots of confusing things in here, and it's partly because, for example, we would allow a preservation program, a project funded out of a preservation program to use some of those capital funds for, you know, some people might use them for a little bit of new construction. So if your preservation project involves some new construction, we will hold you to doing the subsurface soil evaluation. But if you are purely a preservation project, no new building, then we will not hold you to that. And that being in the term sheet is just an FYI that if you have new construction, we want that additional information.
Totally makes sense. Appreciate that clarity. Thank you.
Yep. Okay.
Okay.
Thank you all. This has been great. And good luck.
Thank you.
All right. See you.
Thank you. Bye.
Thank you.